14A District Court is now back in session. All those having business with
Welcome to my channel, The Law Log.
the court draw near. The Honorable Judge J. Cedric Simpson presiding.
And good afternoon.
Courtrooms are where everyday disputes turn into life-changing decisions. Today's case isn't just about rules in a community, it's about whether someone could actually lose their home after living there for nearly 3 decades. But as we're about to see, things get complicated fast.
Afternoon, folks. Court does call the case of Orchard Grove Village versus Jan Butler.
Good morning, Your Honor. Sumchit Hart, P69542 on behalf of Orchard Grove.
Hello, Jan Butler.
Okay. The only thing I have down here, this is a termination case, and it says defendant claims repairs have been made. Is this because of the...
Right away, the judge identifies this as a termination of tenancy case. That means the landlord isn't just asking for a warning theory, asking the court to legally end the tenant's right to live there. In many jurisdictions, that's the first step toward eviction.
Condition of the premises?
No, Your Honor, there's a lot more to the termination than just the condition of the premises. There's unauthorized pets. The minor that resides there has threatened to stab other children with a knife. There's been disturbances to the neighbors, shining lights in their houses, cursing, trespassing on their property. Those are in addition to the home and home site not being maintained.
All right. Ms. Butler, what's your position on all of this?
I've lived here for 30 years. Since 1996, never had any problems until the last year. And the thing is when they're saying that we're shining lights in their windows, we're backing our cars up. And the headlights will shine in their windows for a few seconds. That's all that was. But they wouldn't listen. As far as my granddaughter, we didn't even know what she had done until the police showed up to the door. And the officer said there wasn't nothing going to be done. And that
Here's where things get interesting. The tenant says she's lived there for 30 years with no issues, but the landlord claims serious disturbances involving family members. So the real question becomes, should a tenant lose their home because of alleged behavior from someone else living there? Let me know what you think.
he only stopped there to give her like one of those scared straight speeches. And that's as far as that's concerned. My granddaughter's never been in any issues. And she didn't even have a knife.
Okay. Are you going to get an attorney to represent you on this, ma'am?
I already have an attorney.
Okay. Who said?
We're done when...
Well, hold on, Ms. Butler. Who's your attorney? Because I don't have an attorney of record on this case.
Catherine Girding.
Ms. Hart, have you?
This is a critical courtroom moment. The judge checks the official record and finds no attorney has actually filed an appearance. In legal terms, that means despite what the tenant believes, she may technically be representing herself.
You guys heard from that attorney?
Your Honor, we have heard from an attorney. From what she represented to us, Ms. Butler could not up with the retainer, and she has not filed an appearance. She will not be filing an appearance, from my understanding.
That's
Okay,
funny.
were you aware of that, Ms. Butler?
Actually, I was just in her office last week for the hearing.
There was no attorney that was present last week, Your Honor. I was the attorney of
Yes, there
record.
was. She was sitting right there at the table. Maybe you didn't see
All
her.
right.
She was
All
there.
right. Maybe. Well, ma'am, do you know why she's not here today?
Because she had other court appearances today.
Okay, let me do this because what's her name again?
Her name is Catherine Girding, is from Mars and Terry.
Okay. Last name is spelled?
Gerding.
Yeah, I know who it is. I'm going to pass it briefly. Can you send a message to their office? See if we can get a response as to whether she's representing her. All right. Let me pass the matter briefly. I know this is your only one, Ms. Hart, but let me make sure. Court recalls the case of Orchard Grove versus Butler.
Good afternoon again, Your Honor. Sumchit Hart, P69542 on behalf of Plaintiff Orchard Grove.
Grove. Yes. And Miss Butler's here. Miss Butler, we contacted the attorney and they've indicated to us that you are not being, you haven't retained them to represent you.
I just found that out myself. I didn't know nothing about it.
Okay, well, typically if you don't pay them all the money, you haven't retained them. So, so ma'am, how do you want to proceed on this?
Well, my thing right now is I don't understand what the problem is, because these are all just violations of their rules and regulations. My rent's never been late and my yard is kept up. I don't get it. You know, do they do that to other people around here? Because I've got people in this park.
I don't know, man.
Everything's worse.
All right. So, ma'am, do you want a trial on this or what do you want? Because
what is it they want? What is it their conditions are? Because I can't afford to move my house. And my house is paid off. I'm on disability. And they know this.
Yeah. All right. So I don't know entirely what they want. The only thing that's been brought forth to the court is they want you to move. I don't know if there is any leeway for some type of probationary agreement regarding the tenancy or not. And Ms. Hart, I don't know whether you're aware of whether or not that can occur. But there's somebody here from Orchard Grove because
we do have someone here from Orchard Grove, Your Honor.
Right.
Patrice DeBose is here from Orchard Grove.
Hi, Your Honor. It's Patrice.
Yes, Patrice, how are you? Okay, is there any leeway with reference to a probationary agreement or anything along those lines, or are we just looking to seek straight termination of the tenancy?
My regional manager and I had...
Notice what the judge is doing here. Instead of immediately pushing toward eviction, he's exploring something called a consent judgment that's basically a negotiated agreement between both sides, often with strict conditions that can allow the tenant to stay if they follow specific rules.
Had sent information over to Sunshine. I don't know if you got it or Jen Wilburn had it. We did say that we would be able to do a consent judgment with a no trespass for Cody Butler and Samantha Foes, or William Cody Butler. Because there's been too many times that we've had to do role reminders throughout the years. He was gone at one point and then he came back. And so here we go again. So I don't want to continue to have to deal with that. And now his daughter has threatened children here. So I don't want to continue to have that happen.
Gotcha. Okay, so here's what I'm going to suggest I do. I'm going to adjourn this out to June 16th, 2023 at
16th at 9 a.m.
At 9 a.m. Ms. Butler?
Yes.
At 11 a.m. Yeah, I'm sorry. It's at 11 a.m. is the thing. What you're going to need to do on your paperwork, you have the attorney's phone number.
Yeah,
they're willing to work with you to get a consent judgment with certain criteria that you'd have to abide by. I'm going to suggest that you contact the attorney's office, see if you can work that through. I'll give you guys 2 weeks to try to get that done. Otherwise, they're proceeding that you'd have to leave your home and move your home from the premises. So they're willing to work with you, but they're going to require certain terms.
Your Honor, instead of adjourning this case, if I could have you pass the matter for 10 minutes, I can call Ms. Butler right now, and then we can work out a consent judgment, place it on the record.
I really don't want to, but okay. I'll pass.
Thank you. Ms. Butler, if you could chat your phone number, I will give you a call right now.
Okay.
Thank you, Your Honor.
Yeah. Whatever. Court recalls the case of Orchard Grove versus Jan Butler.
Good afternoon, Your Honor. Sumchit Hart, P69542 on behalf of Plaintiff Orchard Grove.
Ms. Butler, are you still here?
Yep.
Okay, I'll just ask it. Either one of you want to try to yell at me?
Oh,
I don't want to go after that.
If you want to, go for it. I mean, it seems like it's the day. Okay, so. All right. So what have we worked out?
Nothing.
Your Honor, we are unable to come to a resolution. There'll be no consent judgment on this matter.
Got it. Okay. So, Ms. Butler, you want to have this matter set for trial then?
Judge, I was going to call my attorney back and see how much it's going to cost the retainer, because I've already paid her a certain amount of money already. So if there's a chance that I could have until Monday or Tuesday, otherwise I'll have to go down to legal aid.
Okay, here's what I'm going to do. We'll do it this way. And so the parties can understand an expectation. I understand that you may not have known that you have to pay an attorney for them to appear. So what I'm going to do is this. I'm going to adjourn this to June 16th, 2023 at 11 a.m. as I indicated previously before Ms. Hart had her alternative plan. And then from that date, if you have an attorney, then we will proceed. You can expect to see a final settlement conference occurring that next week at 3:30. And then if that doesn't resolve it, a trial after that. Okay?
Yep.
That's where we're at. We'll
Thank
see you in
you,
a couple weeks.
I hope your day gets better.
Well, my day's fine. It's everybody else's day that's going to get bad. Thank you, Ms. Butler. Have a great weekend.
You too, Your Honor.
Whitaker Oaks versus Yates Hickenbottom.
Danny Horn, P81774 for plaintiff, Your Honor.
He's here. Oh, there he is. Where'd they go? Okay, they're there. Okay, what do you have as a balance now, counsel?
Rent to retain $2,007.45. Cost $160. Cost $160 for a total of $2,167.45.
And folks, you previously were denied through Hawk, is that right?
Yes, sir.
Okay. So how are we going to get this paid down or paid off?
I've been making payments, Your Honor, to bring the payment down.
Okay, but so here's what I remember. I think you were going to try to move, right? Because you at a house. When were you planning on trying to do that?
To be honest, I was trying to do that as soon as possible. I just only wanted to do it. I didn't want to have an eviction on my record as if I'm abandoning the place. We're trying to pay the cost down. We was going to, as soon as possible, Your Honor.
Okay. So what? But I need a date that you're looking to try to do that. I mean, I remember everything. I remember you don't want the eviction. You don't want that. I get it. Folks have just got to answer my question so that I can try to see what I can work out for folks. But you had indicated the end of some month. I can't recall whether it was June or July. You had said that you were trying to get yourself moved.
The end of July is actually the end of my lease.
Yeah.
So we've been already looking for a place. It's just if we get an eviction on our record and the place I'm trying to move, we're not gonna be able to move sooner.
Do you have a place to go?
Yes, sir, Your Honor.
Okay. So when you're talking about the eviction on your record, I get why you don't want it, but you keep giving me a rationale for it that's not making a lot of sense to me. Because if you got a home to go to, that eviction on your record is not going to make a hill of beans about you being housed, right?
It's not going to make hill of beans about me being housed right now, but if I want to be housed somewhere else in 2 years, it will. An eviction stays on your record for 7 years, Your Honor.
I've been doing this for a minute, sir. I get it. All right. But, okay.
And that's the tension you see in housing court every day. On one side, property managers pushing for enforcement of rules, on the other, tenants trying to hold on to the homes they've lived in for years. The judge's decision to delay the case gives both sides one last chance to work things out. But if they don't, the next hearing could determine whether someone loses their home.
How are you proposing? You know what? I'm done. How are you proposing to pay this down?
To be honest, I know for a fact I was going to bring them $1,600 on the 28th of this month. I was actually hoping to pay a little bit more before then to help bring it down, because the last time I paid them $1,600, I only owed them $600. So I'm hoping to pay some money along the way, Your Honor. But the whole thing is, as of right now, I get paid every week. But literally, today is the first. Literally on the 5th, my whole pay schedule switches. That's the whole problem I'm getting into. I go from my every week pay to a every 2 week pay. I just started.
Counsel, are you guys willing to work with these folks? I mean, I don't know what else to do because I can't get my questions answered.
Right. Your Honor, last time it does look like there was a discussion potentially about a conditional dismissal. We'd be willing, and Whitaker Oaks can correct me, but if we do until the 13th, which would be the normal statutory period, they've stated they have somewhere to go. If they can vacate by then on a conditional dismissal, then with this being possession only, there would be no eviction for the future. And they would still get the statutory period that they would be entitled to if there was a judgment. My client would get possession back or have the right to get a writ of eviction the next business day. So that's what I would propose, unless Whitaker Oaks has something different, in order to help both parties do and achieve exactly what they want to do. Because frankly, it doesn't sound like payments coming anytime soon.
How does it not sound like payments coming anytime soon when I just gave you guys $1,600? Before I gave you guys $1,600, I gave you guys $250. And before I gave you guys $250, I gave you guys $175. And this was and you guys just took over. This is my first time ever being late on my rent. I can't help that I got sick and I had major surgery. I was in the hospital for over a month. I can't help that. I apologize.
Mr. Yates, Hickenbottom, let me just tell you something. You're not going to come into this courtroom and try to yell at anybody.
I'm not yelling at
It's not, no, it's not going to happen. It's not going to. You want to try to overtalk me? Really? Do you want to do that today? I'll wait for your answer.
No, Your Honor. That wasn't my attempt.
Here's what I'm going to do, because I'm done. I'm going to adjourn this out to the 16th over the objection of plaintiff, because I know they want their judgment today. June 16th, 2023, 9 a.m. Mr. Yates Hickenbottom, I'm just going to tell you this. Maybe you should look at the way that you approach people. Maybe you should go over to the management and try to work out a conditional dismissal. It's going to be up to them and you to work that conditional dismissal out. I'm done. If they come back, you don't have one worked out, I'm granting them a judgment, if that's what they want.
Your Honor,
I'm done. Thank you. 16, 2 weeks. Court will be in recess.
Thank you, Your Honor.